Good morning. Can you hear me? Good morning, everyone. I am Diego Canabera from the committee's advisory committee. I am here substituting Max, who would be here today. So I'm here on his behalf to introduce Mr. Giancarelli. You probably read Bruno's autobiography. He today heads the international unit responsible for data flows and protection at the European Union or Commission within the Public Policy Directorate concerning justice, consumer rights, and gender equality within the European Commission. He also led the delegation of the European Commission and community processes that led to the creation of the framework for data, personal data, and he worked with the Parliament, European Parliament, and with the Council, European Council, in the definition of a new regulation for data protection, personal data protection for the European Union. Bruno is a big leader in negotiations with other countries which have tried to put together data flow among European countries, most notably with other countries, most notably Japan and the US. And he has a long journey in the legal area and also in political science. So it's nice to hear that, Bruno, because I thought I was one of the few crazy guys who had studied both areas. And in practice, he has a very intense intellectual production in the data protection front. So this first keynote could be about the general law of data protection in Brazil and everything which has been happening for the past months as it concerns the final stages of our law, as you just heard in the first panel. But the seminar committee or organizing committee chose to talk about the general data protection issue for the European Union because it has served as a framework for all other countries which want to think about local data protection activities. And you probably all know about the repercussion of the adoption of the GDPR in the media, and you are probably aware of the main issues around that from the technical standpoint all the way through more broad issues such as the impact of the GDPR to international trade and other areas. So we invited Bruno so he could give us this broad overview of the subject. So Bruno, you have the floor. Thank you.
Thank you very much. And let me first thank CGI for inviting me to this seminar and say how pleased and honored I'm to be with you today. This seminar could not have taken place at a more appropriate moment. We've just heard why. Brazil is the place to be in these days, in this week, in this month. And without exaggerating, these are truly historical times for data protection in both Brazil and the EU. And I will try to focus my remarks on that convergence and on the potential and the opportunities of such convergence. This is an area where we already have a lot of common ground, we, Brazil and the EU. We share common values, as notably reflected in our respective constitutional framework, shared values, but also common opportunities, and we've just heard about that. Brazil and the EU both want to fully seize the opportunities of the digital economy, and at the risk of stating the obvious, data plays in that context a fundamental role as a key resource, a key enabler, a key driver of growth, innovation, trade. This is, by the way, increasingly reflected in the cooperation between EU and Brazil in a wide range of issues, from agriculture to smart cities, from research to ICT, to name a few. And to fully unleash the potential of the digital economy, we also need modern, credible, balanced rules of the game when it comes to what can be done with data. This is what our citizens deserve in the EU and in Brazil, and this is also what business needs and asks for, rules of the game. In that respect, it is interesting to see the various calls from many sectors of the Brazilian society, including many sections of the business community, for the quick enactment of the law that has just been mentioned. It was also for us, I've been, as you said, I've led the delegation of the Commission in the negotiation of the GDPR. I would have loved to have a unanimous parliament. I think that you had a unanimous vote represent how much this answers and responds to various needs felt in the Brazilian society. Finally, the EU and Brazil also face common challenges in this area. Recent scandals, revelations, such as, amongst others, Facebook, Cambridge Analytica, have been a wake-up call. They have reminded us of why it is so important to protect privacy, not only at the level of the individual, as a central individual right, but also at the level of the society, as the society taken as a whole, for the preservation of other freedoms, other fundamental freedoms, and ultimately for the functioning of a democracy and the integrity of electoral processes. We have important elections this year in Brazil and in the EU. In other words, we realize how much is at stake from a human rights point of view, as a democratic imperative, but also as an economic necessity. Without consumer trusts in the way their data is handled, there can be no sustainable growth of our increasingly data-driven economy. Rarely has this been clearer than at the present moment. And in a world which is too often characterized by uncertainty and unpredictability, it is very positive and promising that Brazil and the EU are increasingly developing converging responses to these opportunities and challenges. Brazil and the EU, and also together with an increasing number of countries in other regions of the world, as reflected, for instance, and the next panel will deal with that, in the increasingly universal membership of Convention 108 of the Council of Europe. So, before touching upon some of the benefit of this type of convergence, I would like to briefly address some of the key elements. I would say some of the building blocks. A previous speaker has spoken about pillars. Some of the pillars of a modern data protection legislation that balances the respect for privacy with the legitimate needs of business operator. And maybe also say something of our experience with these elements, in the context of the GDPR. I will mention 5 of such elements, 3 pillars, 5 building blocks. First of all, the need for, and Boyana, how many of them you have? 7, so it's a crescendo. First of all, the need for a comprehensive legislation, a comprehensive set of rules that apply across the board rather than sectoral rules. At a time when data is increasingly shared across industries, across business models, but also between the public and the private sector. Let's think about health, let's think about research, let's think about smart cities, which is dominated by public-private partnership in a certain sense. So at a time where we need data to move across sectors, across industry, across business model, we need common rules of the game. In any legislative process, and we saw that very well in the EU during the GDPR negotiation, unfortunately, there are always demands at some point of the process for special rules, specific sectoral rules, sectoral carve-outs, sectoral exclusions. Each sector thinks it is so specific that it needs to be taken care of by special rules. That doesn't really make sense in the digital world. Only a horizontal framework, a framework which is sector and technological neutral, can ensure a level playing field that can deliver both trust and legal certainty, where data can move easily and a level of protection can be guaranteed, a consistent level of protection can be guaranteed to individuals. This is also important at international level. If we want to further develop cooperation, exchange of data, not only in the commercial sphere, but also in the area of regulatory or law enforcement cooperation, where we need also on both sides public authorities to be to comply with some basic fundamental data protection principles. So first element, an overarching framework. Second element, rather than through regulatory silos, which actually create additional costs and obstacles to the movement of data, the broad variety of processing operations that characterize the digital economy should instead be addressed through different legal tools, or to speak the data protection lingo, through different legal grounds, through different legal bases, on which different legal bases on which you can rely to collect and process data. That's the second element. But data need not only consent, but also, for example, processing data which is necessary for the performance of a contract, processing data for reasons of public interest, processing data for the legitimate interest of the business operator. That's a legal grounds mix, if I can call it like this, that you can find in both the GDPR and the Brazilian legislation, which is currently under consideration for final approval for enactment. This has been discussed at length in the context of the GDPR negotiation. And our experience is that if you can get that mix right, and that mix made up of sufficiently different and diverse tools, then you can take care of a very broad range of processing operation. To mention just two examples, from processing in the public sector for some public services to processing in the financial sector for purpose, for instance, of fighting against fraud. You can do this without the need for sectoral legal grounds, without the need for legal basis. And that, again, is a source, it's a source of clarity of the law, therefore of legal certainty, legal clarity, legal security. It's a source of trust for users, and it ensures that level playing field. Similar consideration applied, by the way, in the area of international transfers. As the GDPR and the bill adopted by the Brazilian Congress shows, it is highly desirable and it is perfectly possible to combine a high level of protection on the one hand with openness for international data flows through, again, different tools. To name a few, from consent to contractual clauses or adequacy decision or other tools that you find. You have a long list in the GDPR, you have a quite similar list in the Brazilian bills. It's very important to stress that actually one, high standards of data protection can contribute to the other, trade, exchange of data. Those are not mutually exclusive objectives. Respecting privacy is increasingly a condition for stable, secure, and competitive commercial data flows. Third elements, individuals, and that has already also been mentioned, individual needs to have control over the data. They should be data subject rather than data object. This is, of course, very much linked to the trust dimension of all this. This requires that individuals are clearly informed about what happens to their data, who is processing your data, what data is processed and for which purpose, including in case when data can be stolen or lost, data breach, as these incidents can have very harmful consequences, identity thefts, fraud, etc. This also requires that individuals benefit from a clear set of enforceable rights to effectively exercise such control. These privacy rights range from the most traditional ones, access, rectification, deletion, to those addressing specific challenges of the information society, such as, for example, the right for individuals in certain situations and when important decisions affecting them are taken by automated means, basically algorithms, to be informed about the underlying decision logic and to have the possibility to obtain human intervention, to ask the decision to be reviewed, to take into account some elements that an algorithm may not necessarily have sufficiently taken into consideration. These are not obstacles, as I often hear, to artificial intelligence or other important developments. But this is simply about ensuring that these developments lead to fair results and to avoid discrimination. Nobody here wants to create obstacles, but empower the individuals with the tools that will reassure him or her when sharing his or her data. It's true for Brazil, it's true for the EU, it's true for almost every country in the world. What is the first concern of individuals when they, for instance, shop online? Security and security of the data and privacy. Fourth element, a system based on accountability, coupled with credible enforcement in case of non-compliance, rather than a system based on bureaucratic requirements through, for instance, the need for prior notification or prior authorization, which are burdensome and may delay the offer of goods and services. In that context, bottom-up core regulatory tools such as codes of conduct, certification schemes, can be introduced to support companies in developing their compliance policies and demonstrate when needed and also demonstrate and help the companies demonstrating compliance vis-à-vis the supervisory authorities when needed. And that's, for instance, an area where I think we will see increasing cooperation at international level to develop those codes of conduct, those certification regimes, and help companies navigate between these different regimes. Last, but certainly not the least, in the EU, as well as in many other countries around the world, in the EU experience, the effective implementation of privacy rules depends to a large extent on oversight and enforcement by an independent supervisory authority, an independent data protection authority. I understand that this issue is at the very core of the current discussions in Brazil, the current debate, and this is, of course, a choice that has to be made. I won't enter into this domestic discussion, but I just want to share with you our experience in the EU and why we believe this is an essential part of a modern and effective privacy regime. For at least three reasons. First, it is important for citizens, for the sake of citizens, to ensure that they have an accessible point of contact to answer their queries and handle their complaints without having to go through lengthy and costly court proceedings. This is especially important in the area of privacy, where a lot of queries and complaints are about quite limited, routine, mundane issues, if you want, access, rectification to data. And it's very good in that context to have an independent authority that can act as intermediary between individuals and businesses, and very often help finding appropriate solution outside the confrontational context of a courtroom. It's good for the individual, it's good also for business. Second aspect which is very beneficial to, I would say, legal certainty and having clear rules of the games in place. When it comes to ensuring compliance with the law, data protection authorities or agencies, unlike courts that, of course, look at case on an individual basis, if they come or they don't come, and in a decentralized manner, a data protection authority can ensure consistent enforcement across cases, across the country. This is important to avoid fragmentation in the interpretation. Also, data protection agencies typically have a broader and more flexible toolbox when compared with courts, as they can use both soft instruments, advice, recommendation, warnings, orders, injunctions, or, when necessary, also sanctions, including financial sanctions when needed and when justified in light of the circumstance of the cases. But that I would say that the toolbox, that broad toolbox, is very important to ensure credible enforcement, but also proportionate enforcement that, again, takes care of the circumstances of each cases, and which is much broader than what a court normally has. Third, and probably the most important element and added value of such an agency is that data protection legislation, by definition, has to stay at a certain level of generality. And there's always need for further guidance to ensure uniform interpretation and application, but also to adapt the implementation of the rules to fast evolving technological and economic condition. As I said before, it's important that the legislation remains technologically neutral, but as we know, we are in a world, especially in this area, which evolves very quickly, and where you might have a gap between the law and its interpretation and its application. Having a well-equipped and independent, because independence is also part of legitimacy, authority can help there by developing general guidance instead of having to rule in each and every case, develop a general interpretation, ensure legal certainty, and at the same time adaptability to a changing environment. And that's what we have seen in the EU. In the context of the implementation of the GDPR, contrary to what some predicted, Data Protection Authority did not transform themselves in a sort of fining, sanctioning machines. Instead, they have, if I may say, rolled up their sleeves, engaged with stakeholders in Europe and also outside Europe, actually, and notably issued guidelines on all novel aspects of the GDPR, following wide public consultation. This is certainly the approach, the supervision culture that we in the European Union and at the European Commission certainly want to promote. Compliance with data protection rules, and I know there are concerns, does not happen in one day, overnight. It's a dynamic process, and a dialogue with an independent, well-equipped, well-resourced data protection authority is a key part of that process. So yes, certainly the creation of an authority, an agency, is an investment. But in Europe, we believe, if I can put it in those terms, that it's public money well spent. As not having such an authority can involve down the road significant risks and costs in terms of fragmentation in the interpretation of the rules, legal uncertainty, rigidity, overall rigidity of the system, compliance costs, etc. I could probably go on and on, including by mentioning how modern privacy laws can contribute to innovation, incentivize the development of privacy and data security enhancing technologies through, for instance, a risk-based approach. But ladies and gentlemen, let me come to a close. Of course, in privacy, like in many other areas one can think of, there is no one-size-fits-all approach or model. And it is for each country to design its own data protection system adapted to its own needs, policy choices, conditions, and legal tradition. But the fact that Brazil is participating actively to this clear trend towards global convergence is a very significant and extremely positive development. First of all, I believe for Brazil itself, for the protection of its citizens, for helping its companies to navigate better between different systems, cutting compliance costs, and enhancing Brazil integration in the global data-driven economy. Also, at a time when there is an increasing need for international standard in this area, a global player like Brazil could play a leading role in Latin America and beyond in the shaping of such standards. Very good news, for instance, that we have heard that Brazil is considering becoming observer and I hope member to Convention 108 of the Council of Europe. The voice of Brazil had in related areas, had played a leading role in the past. We all remember Marco Civil. I think the voice of Brazil is expected on these issues. As European Union, and this will be my very last words, as European Union, we certainly very much welcome these developments. Brazil is one of our most important partners. Politically, economically, we are the second trading partner of Brazil. We are the first foreign investor in Brazil, but also culturally. We believe we could further develop our cooperation in this area. Regulatory convergence through, for instance, the adoption of the law which is under consideration could significantly facilitate data flows and, for instance, complement the free trade agreement we are currently negotiating with Brazil in the context of Mercosur. We can further build on the convergence such a law would bring, including through a so-called adequacy decision by the European Union, which would ensure the free and uninhibited flow of data between the EU and Brazil. An adequacy decision is a decision that assimilates a third country, like in this case Brazil, to a member country of the EU, and ensures that data can move from the EU to that third country as it moves within the EU between, I don't know, Italy and France, France and Germany. It is a way to unleash the potential of data flows without subjecting them to any additional safeguards or condition. We have just, and you recall it, we have just concluded that deal, similar arrangement with Japan, creating, by the way, the biggest area of free and safe data flows in the world. This is something we certainly want to explore with Brazil. So, as you can see, we can and we should be ambitious in this area. Thank you very much for your attention.
Thank you very much for being extremely generous. First, for dealing so beautifully with time and giving us some more minutes for discussions. And secondly, for bringing to us a very precise, concise summary of a personal data privacy law. And I think that this is really important and will serve as a foundation for our future sessions of work here in the seminar. Before opening to questions, I would like to make two comments. One about convergency of Brazil and European Union. For us that work with internet governance, this is really important, and it's related with the World Summit for confirmation when Professor Rodota just brought us to a side and started working in a statement of principles, a bill of principles, fundamental principles for governability of internet in the world, which has led to our 10 principles at CGI, and indirectly influenced all the legal framework that we have now with the Marco Civil of Internet in Brazil. There was also Edward Snowden disclosures, which brought European countries and Brazil addressing privacy of data, bringing it to the UN, and later Brazil hosted the NET meeting here in Brazil, where personal data privacy was one of the key topics. I think that convergency and harmonization concerning regulation or rules and laws. Said all that, I would like to know if there are questions from the audience or comments so that we can keep on hearing Bruno. So we have microphones. There is someone on the back. So if you have a question, please raise your hand, say your name and your organization, something about you very briefly, so that Bruno can be contextualized. Good morning. My name is Andrea Villamy. I am a DPO and I work in Europe as well. And I would like to know about Brazil's position concerning a framework of data transfer. What are your thoughts about it? Let me now ask for the second question. Let's gather some questions, Bruno, and then we have them all answered. Would that be okay for you? My name is Aristides. I am a lawyer, and similar to what we have just heard, with the new legislation, will Brazil fit? Because only Argentina in South America is part of that. Can we follow the same line for data transfer with European Union countries?
I have one here. United Health Group. I have a question regarding the training of personnel, because I think it's a big challenge as well. So what we are doing for structuring a curriculum for bringing the professionals to support companies and public sector into complying with such a law.
Let me now ask Bruno. Let me now ask Bruno to answer those 3 questions, and then we can open for further questions. And he is just repeating the question that has been asked to you in English about training of different players, just to make sure that Brazilian players can really comply with the European rules. So how can we really update the curriculum of our teaching organizations and all that? Whenever you ask a question in English, please let us know, right? Because we have all the 2 languages. Or maybe you can ask your questions in Portuguese, because we have a translation booth.
I think I've better understood the question in Portuguese than in English, but that was maybe because of the audio. On data transfer, well, we certainly consider that the adoption of this legislation, again, it's not for me to enter into a domestic debate. I'm not Brazilian, nobody is perfect. But looking at this from the outside, this is a legislation which is extremely interesting because it presents a number of points, and some of them I've mentioned, of points of convergence, of commonality, that indeed for us would be the basis to work on a so-called adequacy decision, and therefore ensure the free flow of data between the EU and Brazil, and I hope between Brazil and the EU, and have the sort of similar deal we just conclude with Japan. Of course, the existence of a independent data protection agency authority would be absolutely central and crucial to build that convergence. We are, and I'm saying this today, but this is something that we had 2 years ago. The Commission had defined what would be its strategy in terms of data flows. We had adopted the GDPR, and we said, well, now we need to focus more on the international dimension. And we had mentioned Brazil as one of the few priority countries we wanted to focus on and to work with, because we could see that this convergence was coming, but also because of the importance of our relationship, trade, economic, cultural, political, and because indeed we are also negotiating a free trade agreement, and the 2 could create very important and interesting synergies, as trade, of course, relies increasingly on data flows. So we would welcome very much the adoption of this law, and we would, and I've said this to the Brazilian authorities so they know that we would immediately start working with Brazil in reaching such an objective. Somebody mentioned other countries in Latin America. Yes, this is also very interesting, because we see that this need for convergence is, of course, important for the relationship between the EU and Latin America, but it is also something which is felt at regional level, where and some very important standards were adopted last year, the Ibero-American standards, that show that, again, this is not about photocopying one model or the other, that through the local domestic needs, legal tradition instrument, one can develop a modern data protection legislation. And we've seen Argentina and Uruguay actually is the other country have been mentioned, but we've seen, for instance, in Chile, Chile had just decided to introduce data protection as a fundamental right in its own constitution, has decided to set an independent agency and is also considering the adoption of a law. That's an example amongst many others. But yes, we would very much, we are very eager to work on Brazil and have that area of free flow of data with Brazil. The other question was, I understand, on the training of Brazilian to comply with the GDPR. Well, again, if another good news that this law would bring is that we would have very similar rules, and therefore complying with Brazilian law would mean that to a very large extent you would use the same rules, the same principles, the same safeguards as under the GDPR. It's good in terms of compliance cost. It's also good in terms of developing, because that's what companies in general want, having compliance program that they can roll out throughout jurisdiction. What we've seen with the adoption of the GDPR, what we can say about few months of experience with the adoption of the GDPR is, of course, the level of knowledge, awareness differs very much across industries, across business models. Companies that have a very data-intensive type of model are already very aware about this, because before being a regulatory requirement, this is a question of reputation, this is a question of trust, this is a question of value. For companies that, of course, are a bit less exposed, this indeed requires a certain evolution, a certain awareness or sense of privacy culture, and that's a role, and that's another role that a good privacy data protection agency and authority can play. Is about again diffusing that type of culture. Some of our data protection authorities in Europe have done something very simple, but which have been very useful, having helplines, hotlines for small and medium companies to ask very simple but very important questions. Through that and other training programs, a lot can be done. What we have also seen through this compliance efforts in the EU, which again is not finished, it's an evolving and it's a dynamic process, is that, well, many companies have then to go and look back and do some house cleaning and look and do a sort of data mapping, which type of data I collect, for which purpose, and what do I do with that data? Do I just send an email every 6 months to my customers with some news on my new products? Do I sell it? Do I share it with third parties? All this, of course, is possible. It just has to take place within certain safeguards. And that sort of, if you want, checkup or health check or data check inside the company is a very healthy thing to do, which actually is, first of all, a good business practice before being something which is required by laws or regulation, because many companies have first discovered or figured out that they were collecting all sorts of data which is unnecessary for their business model, and therefore they were unnecessarily exposing themselves to liabilities. But others have also found that they were not doing anything with their data, or were not doing sufficiently with the data, or they were not exploiting that data. And as we know, this is a very important resource, sometimes a gold mine on which you may be sitting. I don't know if this answers, but...
Well, I believe you have answered the questions. We still have got 5 minutes. I can see 2 hands for people. Maybe if you are brief, we can try to get your 4 questions and see if we have time. We still have got 5 minutes. So last person there, back of the room. Then there is someone in the middle of the room and 2 people here in the front. So if you can be brief, to 30 seconds, we can have 3 minutes for Bruno to answer the questions. Good morning. I'm Danielle with Packard Lawyers. Bruno mentioned the importance of having an independent authority for UN in its general data protection and an independent authority to have an observation and inspection so that we could favorably have a decision in Brazil. I understand that EU countries have their local authorities, and probably there are differences, regional differences, cultural differences that also influence on enforcement, on effective inspection. What would be the level, what would be taken into consideration by European Union when analyzing this independent authority in Brazil so that we could be favorably included as part of this free agreement? Good morning. I'm Paulo Purkett. I'm a lawyer specialized in digital law. My question concerns the fact that GDPR, one size doesn't fit all. In other words, there has been a process of adaptation to the different countries. What are the key issues, key points that have been used during the adaptation process? And here we have Ana Mara. Good morning, I'm Ana Mara with the Public Prosecution Office in Brazil. The regulation of data protection in EU applies to all those who live in the European Union, even though data protection takes place outside the territory. And it also applies application according to international law of some member countries. So it would be applicable to someone who is a national from an European country who lives abroad. According to international law, that would be my interpretation. I think it's Article 3 of the regulation. So my question is, how have you been facing this issue? If there is any conflict between, let's say, the United States, where they have a different type, different criteria, and a different understanding of articles of incorporation and companies. And the last question. Hi, my name is Bruno as well. I'm with Terra Time. I'm a journalist. Well, if the Brazilian law doesn't have an independent authority, would that prevent us from having free flow of data with Europe or European Union? Okay.
So I will try to answer all this question in 1 minute and 46 seconds. So there are, I will try to group them. There are two questions about the independent authority.
We're actually working on that, so just 1 second.
One about the scope, and I must say the other one, I'm not sure I have understood what are the main points during the adaptation process.
So actually, what were the adaptations that you guys had to make in order to accommodate all the interests of the countries involved?
Okay. Within the EU. Okay, so starting maybe with the scope. Let me clarify something here, because your reading is of the regulations is partly correct. The GDPR applies only to the processing of data of individuals in the EU, regardless of nationality and citizenship. So that means me, when I'm back in at home in Europe, or you, Brazilian, when you are as tourist or as or visiting Europe for business reasons. When you are in Europe and your data is processed, then it is subject to the GDPR. Of course, for clear rules of international law and others, and for clear rules on jurisdiction. When I am abroad, including in Brazil, when this hotel collects my data when I check in, or when I had to sign a form to allow this organization to use my pictures, voice, and I had to put all sorts of information, including whether I'm married or not, etc., which is a very interesting piece of information for this purpose. Well, this, of course, happened only, EU law doesn't apply to that. Whether I am, regardless of whether I'm a EU citizen or not, I am subject to Brazilian data protection law. What has changed with this article of the regulation is that we say, well, you can be you can have a company which is not established in the EU, but because of its activity, targets specifically individuals in the EU, offers them goods and services, targeting them, and allowing them to, you can have a website in Brazil and still allow me to buy that service or that good in euro, for instance, that you would clearly target users, consumers in the EU. So in the digital economy, as we know, you can have an impact on another market, on a population, on the privacy of people, also from a remote distance. So whether the physical criteria of whether you are established or not in the EU as a company processing data is no longer relevant, again, if you target specifically in consumers in the EU. This is simply again, a common sense, almost a leveling playing field rule. If you want to access to the EU market of 500 million consumers, then you are subject to the rules whether you are established or not in the EU as a company. So that's what the GDPR has added, if you want, to our protection rules in terms of scope, and there's no application of the GDPR to territories or Europeans moving around in other countries of the globe. Then there were questions on the independence. What is independence? I don't know how many lawyers are in this room, but of course, if we start to discuss about a notion like independence, there might be very different views. And indeed, there are different ways to organize that independence. But I would say that independence concerns three different aspects. I would say a structural, organizational aspect, functional aspect, and then the powers, the function that that authority has. An organizational aspect is that indeed in the EU we have different models. We have some data protection authorities that are appointed by Parliament, other by government, other by a combination. We have some data protection authorities that have that are both the data protection authorities and the authority responsible for access to public information. But what is important is that the members of these authorities, regardless of who appoints them, and often you have a combination of a government appointment confirmed by Parliament, they enjoy an independence, a structural independence, which means that they cannot be removed or dismissed just because they didn't take a decision that pleases the Parliament or the government, and this kind of things, so that they are protected like general members of the judiciary are protected from. Functional independence in the sense that when they are taking their decision, when they are investigating cases, when they are deciding whether a violation deserves or not a sanction, when they are issuing guidelines, they have to be independent in the sense that they cannot be subject to direct or indirect instructions by anybody. Of course, they act under the control of the judiciary as any public body, but in the exercise of their function, that exercise might be free from influence, from instructions from anybody else. And then, what is very important, if we want to have an effective and truly independence, as we know, independence is also a question of means. They have to have the expertise, the resources, the powers that ensure them to effectively exercise their functions. Let me say something maybe on sanction on that. I hear often, because that was very easy for the headlines of newspaper, GDPR means 4% fine for violation of data protection law. Again, it's one of those simplification myths, or if not urban legend, of the GDPR. The GDPR considers that data protection, like any other area of law, and in this area of law in particular, is something serious for which and certain violation can be extremely harmful, and therefore you need to have credible, proportionate but credible sanction. Also, and this is also good for business, because in a system where you don't have any sanction, compliance has no value, and it's a system which is open to free riders. What we have introduced in terms of sanction is a toolbox where you have financial sanction, and 4% is the maximum amount that, of course, has to be calculated in function of 11 different elements that are listed in the GDPR, the duration, the gravity, the negligent or deliberate nature of the violation, but there are also alternative measures that can be taken in case, for instance, the violation is only of a minor nature. Injunctive relief, warnings, recommendation before going to sanction. So we have a broad tool. Yes. Then the question was, including from Bruno, was, well, what are you looking for to have this adequacy decision? What do you really need? Well, adequacy is not about identity. It's not about me going around and trying to find photocopies of the GDPR. But indeed, there should be effective oversight and effective enforcement, and an independent data protection authority is a central requirement in an adequacy finding. How this authority is organized, these are also matters of local constitutional law, public law. All this, of course, can be dealt with in different ways in different systems. But let me, and that will be my final word, does it mean that if there's no adequacy decision, there's no flow of data between the EU and Brazil? Of course not. We have, as I tried to explain, we have, as you have in the Brazilian law, a broad ranges of different tools for transfers, contract, consent, binding, what we call binding corporate rules. But the advantage, and it's an extremely important advantage of an adequacy decision, is that with an adequacy decision, Brazil is assimilated to a member country of the EU. You don't need to have to show any, you don't need to put in place any other safeguards. You don't need to put in place, you're not subject to any other requirements in terms of having, for instance, specific contractual clauses that provide for specific safeguards. So it's an enormous advantage, especially for small and medium enterprises in terms of reduced costs. And it's an enormous, and it's a very significant facilitator of exchange. We believe that, and again, this is a sovereign choice that Brazil has today, that on the basis of the legislation as we can see it today, this would be excellent basis for building an arrangement, an adequacy arrangement. And then I have no time to answer to the last question, which was what are the main points that we had during our own internal process. Many of the points I mentioned, whether to include the public sector or not. And we solve it by having an overarching legislation. How to ensure that balance by having many tools, many grounds for processing and also for further processing. What are the conditions and the limitations for the exercise of certain rights? What about the introduction of new rights? We introduced new rights. Data breach notification, is 72 hours too short or not? For instance, that was a big, but nobody really looked and saw that it's in principle 72 hours. Our data protection authorities have explained that if you need more time, you just need to inform the authority. That also shows how a data protection authority can interpret the rules. Portability was a big discussion. So we had, it's 99 articles. I think we had 99 discussions, and they took a long time. That's why also it is, I'm full of admiration for the work of the Brazilian Congress, which reached unanimity on such a good text in a relatively short time. Probably we need to come here and learn something from you. So thank you very much.